Ready? Start. This civil miscellaneous application is filed by applicant for his appointment as manager of estate of his mentally disabled brother Rakesh under the provisions of Mental Health Act 1987 para. The brief facts of the application are as under para. It is case of applicant that applicant and disabled person Rakesh are real brothers. Their parents are expired. Disabled person Rakesh is suffering from disease schizophrenia since January 2001 and he is taking treatment. Due to his disease, Rakesh became insane and unsound mind, so he is not in a position to maintain his properties and take care of himself. Hence, the application for his appointment as manager of the estate belongs to disabled person para. Learned AGP failed to appear and contest the application. Public notice and proclamation have been issued to call objections of aggrieved person, if any, from public at large. No one is appeared and contest the application on any ground. So application proceed uncontested. Para. Following points arise for my determination and my findings thereon for the reasons stated below are: whether application under Mental Health Act 1987 is maintainable, would it being just and proper to appoint applicant as manager of the estate of disabled person Rakesh. Para. Learned advocate for applicant has submitted that as per section 52 of Mental Health Act 1987, this court has jurisdiction to appoint manager for estate of disabled person. Learned advocate for applicant also relied upon section 50, 51, 53 and 54 of the Mental Health Act 1987 para. Though this application has filed by applicant under Mental Health Act 1987, the Mental Health Care Act 2017 came into force on 7th April 2017. As per section 126 of Mental Health Care Act 2017, the Mental Health Act 1987 is repealed. So the provisions of Mental Health Act 1987 are no more applicable since the date of enforcement of Mental Health Care Act 2017. Thus, application filed by applicant under Mental Health Act 1987 is not maintainable para. So also, as per provisions in Mental Health Care Act 2017, state government has to appoint authority and constitute board to deal with the rights, protection, etc. of the mentally ill person. Special provisions have been made in this act to determine the mental illness and capacity of the mental ill person to make decision, etc. This shows that as per provisions of New Mental Health Care Act 2017, only appropriate authority or the board constituted under this act has jurisdiction and power to deal with the matters. So I am of the view that present application filed by applicant is not maintainable in this court. Hence I answer point number 1 in the negative para. As to point number 2, applicant came with case that disabled person is his younger brother, he is insane and unsound mind. He came with case that his parents no more, so except him there is none to take care of disabled person and his estate. Para. On going through the documents produced by applicant, it reveals that father of applicant and disabled person Rakesh, that is Suresh, expired on 10th January 1998, and their mother Kavita expired on 20th February 2000. The documents in respect of treatment given to disabled person goes to show that he is having some psychic issues and is taking treatment since 2001. Para. Though it is case of applicant that disabled person is taking treatment since 2001, he failed to lead evidence to that effect. So in my opinion, the version of applicant that disabled person is under treatment since 2001 is not acceptable. Para. So also admittedly, disabled person is engineering student. During pendency of this application, I have asked applicant to brought disabled person Rakesh before me. I have asked certain questions to him and talk with him. He has given rational answers to all the questions asked by me. So in my opinion, disabled person Rakesh might have suffering from some psychic problems, and grievousness of his psychicness might have increased, but it doesn't mean that he became insane or unsound mind as contended by applicant. So in my opinion, it would not just and proper to appoint applicant as manager of estate of Rakesh as spread by the applicant. Para. As I already pointed above, the evidence laid by applicant is not sufficient to hold that Rakesh is suffering from schizophrenia since 2001, though applicant has produced disability certificate. As I have already pointed above, I personally talk with alleged disabled person Rakesh. He has given rational answers to all my questions. So it would not be just and proper to arrive at conclusion that Rakesh is insane or unsound mind person so as to appoint applicant as manager to manage his property. Hence I answer point number 2 and 3. I proceed to pass following order. Application is rejected.